Hello and welcome to the continuing series of CLEs by the Boulder County Bar Association in response to the Marshall fires. Today's CLE is going to be Landlord-Tenant Issues following the Marshall fire. I'm Brett Landis. I'm the managing attorney with Boulder County Legal Services, the local Colorado Legal Services office. We provide free legal services to low-income and senior residents of our community. And a big chunk of our work is focused on housing law. Right now I have with me Matt Forstie, who is a fellowship attorney with our office. He does a lot of his casework in landlord-tenant issues as well as consumer issues. And we're hoping today will help you advise clients as you go forward and respond to the Marshall Fire's needs. I will emphasize before we get started, this is a training for attorneys specifically. There is some general information that would be helpful, but any individual watching this who's not an attorney, if you have a legal issue around a landlord-tenant issue, we highly suggest that you contact an attorney's office, whether it be our office or one of our private bar colleagues. To give you a brief overview of what we're going to be talking about today, we're going to discuss some of the issues directly related to the fire. So, homes that were completely lost to the fire and homes that were damaged significantly to the fire. This is also going to lead us into a discussion of the Warrant of Habitability, which is the law in Colorado that dictates what is habitable and what isn't. And then we'll talk a little bit about loss of personal property. We're going to touch on some issues related to temporary housing that may come up, as well as some mobile home park issues. These both have some different rules and different considerations. And then we'll finish up going over some resources and referrals that might be helpful for your clients.
So I'll start by talking through basically the two big scenarios that we're going to see and are already seeing in terms of rental units that were affected by the Marshall fire. And that's first, rental units that were unfortunately just completely lost to the fire, and then the second situation, which is actually a bit more complex and in fact specific, is rental units that were damaged but not completely destroyed by the fire. So I'll start by talking about the two main scenarios that we're seeing in terms of landlord-tenant law following the fire. We've kind of broken these up into two factual buckets. The first being where the rental unit was unfortunately completely lost, and the second being where the rental unit was damaged but not completely lost, which actually is going to tend to be a little bit more complex in terms of landlord-tenant issues. So just jumping into that first scenario, the situations where the rental unit was completely lost, these are actually relatively straightforward in terms of dealing with or unwinding the legal relationship between the landlord and the tenant. And the first step in this analysis is always going to be to become familiar with the terms of the lease. And that's because many leases are going to have some type of disaster provision or provision that allows termination under certain circumstances, and possibly terms that govern what a termination looks like. And so it's important to become familiar with those as a first step of the analysis. But in most situations, the tenant's right to occupy the unit and the tenant's obligation to pay rent is going to terminate as a result of the complete loss.
Should we talk about the common law?
Yeah. So there is a bit of a tension or a caveat to what I just said, that being an old property common law rule that the tenant's obligation to pay rent does not necessarily terminate just because a structure on the tenant's land was destroyed. But that's, I think, in tension with both kind of our modern understanding of what a lease is, what you're actually contracting for, and a modern common contract principle that if the subject matter of the contract is destroyed, then that would lead to, in this factual situation, the contract terminating by operation of law. So I think best practices or advice would be that the landlord and tenant in this situation should just execute a lease termination in writing. The landlord should return the security deposit, which in most cases is going to be within 30 or 60 days, 60 days being the statutory maximum as long as the lease says 60 days. But of course, just the best thing to do there is just look to the lease and the Security Deposit Act for how the security deposit should be returned. And I think interpretation of the Security Deposit Act in this context would be, the landlord shouldn't be able to deduct for the fire's, destruction of the unit, but the landlord, of course, could deduct for any rent that was unpaid at the time the unit was destroyed, or unpaid fees or things of that nature. But if the tenant was current on rent and fees, then I think in most cases the full deposit should be returned. And one other issue I just wanted to mention, I've been at the Disaster Assistance Center a few days speaking with landlords, tenants, and homeowners, and an interesting issue that popped up in the landlord-tenant context was tenants who unfortunately are displaced because of the complete loss of a structure, but think they may have some possessions left behind that may actually be recoverable in the rubble. This is mostly going to be like certain types of jewelry. I heard platinum jewelry is one of the things that might be recoverable with the sifting devices. And so that's something for folks in this situation to think about if they're executing a lease termination, but some sifting potentially that might not even be able to take place for weeks, might be able to recover some of the tenant's possessions. They should come up with a plan for that. And I think in most situations, that's an easy negotiation.
Yeah, and I would say, communicate early and often, or advise your clients to communicate early and often. A lot of these problems can be thought of beforehand and discussed beforehand with the landlord. And I would imagine there is probably some will to be reasonable towards one another right now.
Yeah, so the second kind of factual bucket and the thornier one is rental units that were damaged. And this can take a couple of different forms. I mean, it could include actual structural damage from the fire, or simply smoke and ash damage, which when I was at the Disaster Assistance Center recently, heard a lot of tenants and landlords wondering, what does the smoke damage mean for me? Is it safe to be in the unit? How do I get it evaluated and understand from a professional if it's safe and what mitigation might be required? And so I think those are very active issues still, and I don't know that there's clear answers across the board. I think it's going to take time to figure a lot of that out. But I think the first question that folks that find themselves in this situation now are dealing with is figuring out if their unit is habitable. And some people feel confident enough about that they've moved back into their units. And I think some tenants are still displaced because they're not quite sure yet if their unit is habitable. So that's really the first question, and I don't think we're all the way there yet on answering it. But I do know that Boulder County is holding a town hall on January 20th at 6 p.m. And I believe air quality and these types of issues are going to be discussed on that town hall. So I did just want to plug that. And I do know that Boulder County officials are planning to do more of a door-to-door kind of visits to damaged units, which may be able to provide a little more clarity around this too.
And I think one consideration as well is tenants with disabilities.
Sure.
Some people might be totally fine if they have great healthy lungs that run marathons. But if you have someone with COPD or asthma or even something that sounds as innocuous as severe allergies, their exposure to smoke is going to take a different toll and may make an otherwise habitable unit uninhabitable.
So, kind of a second question that folks are encountering is, if repairs are necessary, who's going to be responsible for making them? And that's another situation where the first step of the analysis is going to be the lease, because the lease can allocate some of those duties in terms of who's responsible for maintenance and repair. And this is one of the areas where the Warranty of Habitability law that I think Brett will talk about in more detail does play some importance, because the law itself says that landlords and tenants in certain situations, it's going to be private, single-family home only, can actually contract around the warranty of habitability and assign more repair and maintenance rights to the tenant via assigned writing. So that's something to look out for as well. I think our advice for most tenants who have repairs that they think need to be done and think that their landlord may be obligated to do them under the lease would be perform a good visual inspection of the unit, document the issues via photographs, videos, and provide a written statement to the landlord outlining the repairs that are necessary. A third important question for these damaged but not destroyed units is under what circumstances could the lease be terminated? And that's, again, I'm repeating myself here, but the lease is the place to start there, because the lease almost certainly says when it can be terminated or provides for some circumstances where it can be. And even if there isn't a lease termination clause, the warranty of habitability law is a second step in this analysis. The tenant may have an ability to terminate the lease under the warranty of habitability if certain steps are followed. I think Brett will cover those in a little bit more detail. And I think Brett will probably repeat me on this too, but I think our advice to landlords or tenants who want to terminate the lease over the objection of the other party is seek legal advice and make sure you do it the right way.
Yeah.
And so the last kind of question here we're getting from folks is, I think my unit was damaged, there was some smoke damage, can I stop paying my rent for now? And the answer to that is no. Keep paying your rent if your tenancy is going to continue, unless and until a lease termination has been entered into or some other agreement with the landlord has been reached. I think there's always the potential for compromises or agreements to reduce rent under certain circumstances, but unless you have some type of agreement in place, continue paying the rent to continue the tenancy.
So we're going to move on and dive into the warranty of habitability a little bit more. This law actually has some really interesting history in Colorado in that, for a long time it was just kind of the common law, and then it got codified, and then there was some case law going back and forth, and then fairly recently, in the past, I want to say 2 or 3 years, it's been significantly strengthened and given a little bit more teeth. But basically, this is the warranty that if you're going to be renting a piece of property, it's got to be fit for human habitation. Sounds fairly straightforward. You'd be surprised at how many times that is deeply disputed. So this is under CRS 3812, and it's the 500 series that goes in this. And really, and I'm just going to look at my notes real quick, what this means is that you have to have running water. You have to have doors and windows that shut and lock. You have to have floors. You have to not have electrical problems that are going to burn the place down. There are very specific rules about mold if mold becomes an issue in any of these. Where it doesn't really get specific is talking about fires. The statute CRS 3812-505 includes a non-exclusive list of these conditions, but again, it's non-exclusive, and smoke and air quality, fire damage, those are not things that are specifically addressed. It's going to be a little bit more of a judgment call as to whether or not a home is habitable. The definition it's a fairly high bar. It can't just be like the air conditioner is not working. That's always the example I use, but it's got to be something that either violates a housing code or would actually interfere with someone's life, health, or safety. And really the key to this is getting a written notice out to the landlord. So I can't tell you how many tenants think that a phone call is enough to really put their concerns on record. As Matt was saying earlier, for anyone who is looking at some damage to their home that they rent, you really want to document with photographs, but for the purpose of the statute, you need to give the landlord written notice, and it has to be written. It can be by email, but it just has to be something in writing. And I always tell people, keep a copy of whatever you send. Again, as lawyers, we all do that, but most normal people don't always keep a copy of everything they send. So if you're advising someone, make sure you emphasize that point so that they can not only give the landlord written notice, but prove they gave the landlord written notice. So my normal procedure for logistically how we actually get this to happen would be to start with a first notice to the landlord, explaining, here's this problem, this is exactly what it is, this is where it is. The landlord is supposed to respond within about 24 hours under the statute. Sometimes it can be a little bit more, sometimes it can be a little less, sometimes the response is really not helpful and is simply something like, oh, well, I received your concern, thank you. But there are some new statutory deadlines for landlords to actually do something. So for something that's really going to be endangering someone's health, safety, or life, you need to have a landlord start the repairs within 24 hours or start some sort of action. For all other habitability issues that aren't quite as dangerous, it's 96 hours after the complaint. And this is one of the newer concerns in here. So that would be step one, is getting that notice, getting the response. If there either hasn't been a response within those time frames, or if the response is not helpful, or I got it but I'm not doing anything, or I got it but it's too expensive to fix, you're going to want to move to step two, which is to send a second letter to the landlord. The second letter should basically outline what the tenant wants to do if the landlord doesn't make the repairs. And typically you're going to give the landlord about 5 days to make the repairs after the second letter, and include that in the letter. If the tenant is wanting to break the lease, so that is definitely one of the remedies if the home's uninhabitable. They need to give the landlord a date 10 to 30 days out from that second letter of when the lease is going to terminate if the repairs don't get made. That is often, unfortunately, the most workable option for most people. And that's, I think, what most people try to do, even with the difficulty of finding a new home. And I think it's no secret that housing and good housing in our community is a hot commodity and an expensive one. So that finding the new place to move into if the old place is uninhabitable is often the trickiest one. I will say in this particular circumstance with the fires, I think that may be a little easier for people to do, which is to terminate the lease, because they're most likely already out of the home. They had to evacuate and haven't been able to return. So you actually have them somewhere else, and terminating the lease is just going to free up some of their income to actually pay for rent in a new place. Another option that you can threaten in the second notice is to sue for either an injunction or damages with the court. This is not done very often. I think part of it is the process in the courts does not move as fast as I think a lot of people in these situations really need it to. So it tends to be something that, at least in the short term, is not a great way to handle things. I will say the option to sue for damages extends for about a year. It's got a 1 year statute of limitations. So if someone does incur expenses dealing with uninhabitable residence or trying to fix it or trying to manage, have them keep their receipts. They should be keeping their receipts anyways to document any FEMA claims they might have, but for this purpose, they need to keep their receipts. because they do have a full year after the issue to bring a claim in court if they need to get reimbursement for those. And then the third option is to deduct the repair cost from the rent. My big concern with doing that is, well, I have a couple concerns. The big concern is that your client might then get sued for an eviction for non-payment of rent, and then you're having to defend your client against an eviction action, which is never a fun thing to do. But in the other kind of concern in a situation like this is that the repairs might be more than a month's worth of rent. And I think very reasonably from some of the early images of the partially damaged homes, that is definitely going to be a concern. So that may not be a feasible option for people. I will say if they are going to deduct rent, they really, really want to do it carefully. And I am going to highly suggest that someone spend a lot of time reading that CRS 38-12-500 series, because that is your Bible in this case. That is going to tell you exactly what to do in very legislature-like language. So definitely, if your client is looking at withholding rent or deducting rent to make repairs, they really need to read that carefully, or you need to read that carefully to advise them on their particular situation. Because there is always a risk that a judge is going to disagree and evict your client, and then they have to deal with having an eviction on their record. Finally, I do want to mention within these statutes, there is one CRS 38-12-503, paragraph 6, that permits a landlord to terminate a lease as a result of a catastrophe, and basically the landlord has the option to end the relationship. I would not be surprised if a lot of landlords are opting to do this just to clean things up and clear things up and get going on rebuilding or selling the property, depending on their own financial circumstance.
Yeah. Maybe two quick things to add, Brett, yes, before we move on. One, I think, one of the sticky warranty of habitability issues could be, the statute says that landlords have to take, I think that the language is employ reasonable efforts within the statutory time frame. And given that, we're in a disaster and contractors are super stretched right now, reasonable probably means something different in a disaster than it means in normal times. So that'll be an important fact. And then I think the other thing just that I'll mention again that I mentioned before is just check to see if your parties have contracted out of the warranty of habitability. And the place to look for that is usually going to be in the lease addenda. You cannot actually contract around the warranty of habitability in the lease itself. It has to be a separate signed writing. So it'll usually be in that addenda section.
Yeah, and I will say one of the requirements for that too is that the tenant has the ability to make those repairs. So, if you are renting to a couple in their 90s who are in not great health and worked in as accountants for all their lives and have no skills to remodel, you can't make them responsible for their own plumbing. You can't make them responsible for their own roof. They need to be able to do that.
Okay, so next, loss of personal property. So this is going to be, kind of a tenant focus. Maybe I should just start as a table setting matter. We're not addressing homeowners insurance in this CLE. And the reason for that being because there's an excellent CLE already out there from the BCBA addressing homeowners insurance issues in detail. So of course, landlords are going to be concerned about using that homeowners insurance, but we're just not going to address that here. We're going to focus on what the tenant is going to do in terms of loss of their personal property that was in the unit. And I think the reality in 90+% of situations is the lease is going to say that the tenant has to maintain renter's insurance to cover loss of personal property. So this is going to fall pretty much on the tenant. And it's going to depend on what type of insurance and what their policy limits are in terms of what they're going to be able to recover. But the recommendation is definitely for them to start the claims process ASAP. And as I just said, the landlord's usually not going to have any liability for that loss of personal property in this situation. And kind of part of the backstop that exists for any tenants that may be uninsured or underinsured is FEMA assistance. And Brett, I don't know, you may know better than me how much they may be able to get from FEMA.
I want to say it's around like 35,000. That's the number that I've been seeing. That's not the exact number, but it is somewhere in that realm for personal property. But keep in mind that also covers any replacement housing costs. So it's the other cost section. So it covers quite a bit, and I can imagine that gets eaten up pretty quickly.
Right, but it's definitely significant
but it's
enough
something
where any tenant who thinks they might be underinsured or is completely uninsured should definitely go to FEMA. Yeah, so we were just talking about, the FEMA claims process. So any uninsured, underinsured tenants should go through that process, and they should also they should go to the Disaster Assistance Center if it's still open at the time that you're viewing this presentation. There's a lot of nonprofit assistance available there too.
Yeah, and I will say there is a deadline for applying for some of these FEMA funds. I believe it's 50 days from the date of the loss. So it really is time sensitive, and people need to apply sooner. You can, I think, get an extension for good cause, but good cause is not defined and it's fairly subjective. So safer to get those claims in by the deadline.
And a couple other things I'll mention. One is that, even tenants who just experienced some smoke damage or were outside of the burn area should still look to their renter's insurance policy. They may have been displaced for a while and could get some of those costs covered, and they may have some personal property that isn't a complete loss but needs to be cleaned that the renter's insurance would cover. So they should, of course, go through the claims process for that. And then the last, kind of more resource-focused point here is the State Division of Insurance has a consumer services team who has been, very responsive for fire victims. So that's a good first step for insurance questions or navigating the process. We have their contact information in the slide here.
And again, if you have registered for the CLE, we will make these slides available to the Bar Association to follow up on some of these resources. So next up, we're going to talk about some temporary housing issues.
Yeah, and I think one of the interesting things that we'll see is many longtime homeowners are becoming tenants, and they may not have been tenants for many years or decades.
Yeah, if you've owned your home for a significant amount of time, this is going to be a very new world and a very intimidating and confusing world for a lot of homeowners.
Yeah. So, like for instance, I talked to a couple of folks at the Disaster Assistance Center that brought new leases that they were thinking about signing, and haven't seen one of those for a long time. Mm-hmm. So, that may be an opportunity for counseling that just comes up.
And I think a very good service that attorneys can offer their clients, and whether or not you were someone's divorce attorney 3 years ago, or you drafted a will and powers of attorney for them, reviewing a lease is something that any attorney can do. You can access a number of resources. I am happy to be a resource for any of our local attorneys who have a question about this. We have, I think, through the Bar Association, a few other CLEs on landlord-tenant basics. But yeah, reviewing a lease, noticing if there are any questions that you have, or any clauses that seem unreasonable. But there's a lot of boilerplate in there if someone is renting from a corporate landlord, and there are a lot of things left out sometimes when someone is renting from a private landlord who may only own 1 or 2 properties. So looking that over for completeness is always a good idea.
A practical issue too that I think may come up, and it's going to be different for everyone, but homeowners who are temporarily displaced, they may have as much as a 2 to 3 year timeline that they're going to be tenants for, and we don't know exactly how long, but they may want to take an extra special look at, say they're entering a 1 year tenancy, what happens when the tenancy is up? Do they have an option to renew? Does it become a month-to-month tenancy? Those types of things, while right now, they're probably in the mode where they just want to get into temporary housing ASAP, looking to what happens at the end of that first lease term may become really important to them in terms of remaining housed and remaining comfortable while their home is being rebuilt.
Well, and an important consideration there too is a lot of leases are set for 1 year periods. Yeah. That's the most common amount of time, with month-to-month tenants being the other most common. Right. But a lot of insurance companies will only pay for your housing either while your home is getting rebuilt or for a fixed period of time. So you really want to look at the insurance documents in conjunction with how long of a lease term someone has. Because you don't want people to be in a situation where they've just signed, their house isn't built after 1 year and they're stuck with the option of either sign a new 1 year lease and have 6 months of that not be covered, or you have to break it. So really look at those lease termination clauses. Is there a penalty? How much? I have seen some that are really outrageous for how long someone's going to be on the hook for paying for a unit they don't live in. And maybe have them talk with the landlord or the property manager to see, is it possible to do a 6-month lease? Right. Is it possible to do month to month without an increase in the rent?
I think as folks get closer to that time when their house may be rebuilt, there's going to be a lot of negotiation going on, because they might be stuck in the second year of an annual lease, but their house may be rebuilt at month 19 or something like that. So what happens for the remainder of the lease term? We should just quickly covering, there have been some resources that have popped up for identifying housing. So we've identified those here so that can be passed along to folks. And then a couple of things just to be aware of. We have heard a little bit of kind of rumblings about rental scams that are out there. So just be on the lookout for those, or if you're helping folks find housing, just do what you can to validate and verify.
Yeah, unfortunately, situations like this bring out the best in people, but it also brings out some of the worst. And there have been a number of different scams already going on involving false aid requests. I believe very concerning to our AG's office are scams involving consumer fraud or construction scams. So I think there's a lot of potential that some enterprising scam artist could set up some with rental housing as well.
And then we have heard anecdotally, unconfirmed, some discussion about price gouging. And I did see, an article recently that the Attorney General's office is looking into that. So if you happen to come across specific examples that look like price gouging, I think the advice there would be, report those to the Attorney General's office.
And locally, you can also report those to our community protection unit at the Boulder County District Attorney's Office. They're a great kind of local resource if sending a complaint to the AG's office doesn't work, or you want someone to talk to. So next up, we're going to discuss mobile home parks and mobile home issues. These always work a little differently, and I always want to highlight mobile homes because they are in an odd legal place where someone is a homeowner but doesn't own land. So typically, if someone owns the mobile home itself, oftentimes they can even get a mortgage on this. So if someone's referencing their mortgage, you might want to follow up with a few questions, because that doesn't necessarily mean they also own the property itself. There are some mobile homes where the mobile home park actually owns the mobile home as well as the land underneath it. Those would be treated just as a normal landlord-tenant situation. But for our purposes right here, we're going to be talking specifically about situations where someone owns the mobile home and rents a lot space. typically the park is going to be responsible for common areas. Common areas, utility lines, sewer lines, pretty much everything up until it connects with the mobile home itself. Sometimes they'll be responsible for some structures if there's a shed or a car park that goes with the lot. Sometimes they won't. Definitely want to look at the park resident agreement. They are required to have those and to provide those. A lot of parks, though, you will have people who've lived there for decades, and those documents are long gone. It may also be possible to look, though, at a more recent rules regarding the park to see what the park thinks it's responsible for, at least. Typically, the homeowner, though, is going to be responsible for the home itself. So removing any damage, cleaning up the mobile home itself, that is going to fall to the owner of the mobile home. This is kind of the situation back where we were talking about the common law, where the rental agreement is really to rent the land and runs with the land, to use a term from first year property class, rather than renting the structure on the land because they own the structure. This is another situation where if people have insurance companies, you really want to make sure they make their claims, or if they don't have an insurance on the mobile home, they want to make a FEMA appeal pretty quickly.
Talk about rental assistance quickly, and basically the message is rental assistance is out there. So if you're working with someone that needs it, there are resources out there, both government and nonprofit, and we've listed them here on the slide. I don't know that it makes sense to go through each of them in detail, but I think good first stops are going to be for disaster victims. Definitely FEMA is going to be a good first stop, and then in terms of governmental resources, the Housing Stabilization Program is going to be another excellent one, and then the nonprofits that are listed on the slide here have been great community resources about filling gaps and providing emergency assistance when it's needed right away.
Yeah. And I will just say, one of the odd things about this past year to 2 years is there were a lot of structures put in place for rental assistance to really avoid having a tsunami of evictions, which is, for those of us who work in housing law, was a really big concern for a period of time. And so a lot of the rental assistance programs that are in existence are a direct result of some of the COVID-related money that came through, but a lot of that money can be utilized for other issues. And then I'm going to finish up by talking about some of our other resources that aren't necessarily direct money to people. So one really valuable resource, especially if you're in those first two categories that we talked about of people whose rental homes were entirely lost or significantly damaged. Mediation. We are incredibly lucky in this community to have free mediation with people who are experienced and knowledgeable about landlord-tenant issue. City of Boulder right now, they have a community mediation and resolution center that is being utilized throughout other parts of the county. Longmont also has a community mediation center, but because of the location of the fires in Louisville and Superior, the City of Boulder program is going to be the appropriate place to apply for mediation. It is free. And again, I have worked with many of the professionals in that program, and they are so good and so committed and so patient, and they will do everything in their power to help people reach an agreement. So if someone does have a difficult opposing party, that is a great referral for them, whether the difficult person is the landlord or the tenant. Getting that call from the mediation program is a great way to start the process and to really get people talking to each other, if it's not something that you're gonna retain on. Other legal resources in our community, I really want to emphasize the Boulder County Bar Association's virtual free legal clinic. This is a great program. It was put in place, I think, as early as May of 2020 to basically mimic the advice that people would be getting through our formerly in-person free legal clinic nights. This actually works better in that people can do it on their own time. The attorneys can do it on their own time. There are a number of attorney volunteers, and we've been collecting some additional ones to help with some of these disaster-related questions. So if you are an attorney, please volunteer your time for the legal clinic, and please refer questions you don't know the answer to the legal clinic. It is a wonderful free resource for our community. There is no means testing. Our office is another organization that is providing some help. We do work with people who are considered low income or people over the age of 60 dealing with these issues. So if you are in contact with someone, we are a great referral. And I'm going to say this, and I'll say it again, probably before we sign off. We are always in need of pro bono attorneys. So if you have time to give, if you are interested in helping address some of these issues through clients, please volunteer with us. Our main number is 303-449-7575. But we can very easily put you in contact with our pro bono coordinator, and she will do a great job of giving you clients to work with for free. But it's a great way to give back and to try to help address and help our community heal. There are some basic information available. Boulder County has a whole Marshall Fire webpage. It has some really great resources that our county government is providing in response to everything, as well as it's a great spot to just grab information like operating hours for the DAC, what is the phone number for for one of these agencies. There's also a really good Colorado Division of Insurance town hall that was given, I think, about 2 weeks ago. It was 4 hours long, but it had a lot of information. Matt was good enough to sit in on that one and take notes.
I'll add to that they're going to do a continuing series of town halls doing deep dives on specific insurance issues, kind of as the insurance process plays out and certain subtopics become more relevant for folks. So just keep an eye on those. Yeah.
And I'll finish up just providing my contact information. That is my email, blandis@colegalserve.org, and Matt's email as well. If you do have any questions about how to represent a landlord or tenant in these cases, I can refer you to resources. Really happy to do so. We've been working really hard to get up to speed on a lot of disaster-related issues, as we're expecting to see those in the mid-range, and seeing if we can help our community recover. And if you are an attorney watching this and you would like to get involved by giving back some pro bono service and representing clients, please contact us. There are many areas of law, not just landlord-tenant issues, but we're expecting to see an increase in domestic violence. So family law attorneys are always encouraged to join us. Anyone who has interest in doing any sort of public benefits work, including FEMA appeals, we are happy to sign you up and work with you on training. And any real estate attorneys wanting to do title clearing, come on, you're welcome. So, and again, please sign up for the BCBA's free legal clinic. It is a really good way to make an impact and alleviate someone's anxiety without spending a huge amount of time or the commitment that a full case would. And to sign up for that, please contact the BCBA. With that, I just want to say, I am really impressed at a lot of the ways that our community, and particularly our legal community, have come together. And I hope that bodes well for the rest of the recovery process. Just keeping that spirit of coming together as a community alive for for not just the short term, but as we're still going to see effects of this in the long run. So thank you very much.